My take on that is Nintendo is so wrong it hurts. I don't know why they make that argument.
How many games have a summoning system? Like, how many RPGs have a necromancer or a warlock or a hunter with pets? And Nintendo and the Pokemon Company are saying, actually, we own that and we're going to assert that for the next 20 years.
In fact, you might argue that's why, for example, Nintendo is getting a lot of patents they're getting, is because everyone at the USPTO is too busy. They're not getting enough time to do what they need to do.
You might think that you can't patent a game mechanic. At least that's what I thought. It turns out, especially in recent years, it's not so simple. Kirk Sigmon is an attorney at Banner Witcoff and an expert in U.S. patent law. He joins us this week to make sense of the complicated and wild situation in which Nintendo and the Pokemon Company are posturing for U.S. litigation against Pocketpair, the maker of Palworld. Litigation in Japan is already underway. In the process, Nintendo has secured patents for game mechanics that look a lot like what we've already been playing for the last 30-plus years. There's patent activity relating to mounts and the quick switching of mounts. There are patents about throwing an object to capture a character. And very recently, a new patent was secured that covers the summoning of a character. This is a complicated and niche field, so we'll cover some basics of patent law first before getting into the dirty details of what's been called by far the most aggressive patent enforcement any game maker ever attempted against a rival. Pocketpair is your client, so you can't talk about, Pocketpair strategy or movements or anything like that?
Right. I can give you kind of a high level of what's going on with respect to the scene as a whole, as well as some Nintendo patents, but I can't give you, for example, some opinion on what they're likely to do, to say the least.
Absolutely. So why don't we talk about what patents are supposed to do? And there's supposed to be this tension between sort of protecting innovation and preventing the monopolization of stuff.
Right.
Where do you think that patent law should reside in that tension, and what does that look like in the video game space?
Sure. So at a very, very high level, for those who don't know, this series of the patent world is designed to give what we would call a legal monopoly on innovation, so new and non-obvious inventions of various kinds. And so this has been around since the U.S. Constitution, at least over here in America. And the general idea there is that we want to provide a reward for clever inventors who have done something very new and who want to monopolize their invention, want to sort of protect their invention in a way that is time limited and that is very specifically defined, but in a way that gives them, monetary value in terms of that monopoly. And that's been around forever, that most countries have some sort of scheme like this because there's a lot of value in it. Now, when it comes to software, it's a relatively new area. I say relatively, 30, 40 years at this point, plus. But nonetheless, it has long since been a major dispute whether or not things in the generic software space should be allowed to be patented. And most countries, the US, Australia, Japan, Korea, you name it, have more or less fallen into the category of yes. But where things get uncomfortable, even for the general public, is the question of, where that line is drawn. So with software innovations of any kind, there is a dangerous line between what I would call a genuine software improvement that's, processing data, outputting data, things like that, versus game rules. And as I'm sure you've seen, there is a long series of history in multiple countries saying that the pure application of game rules, so for example, a card game rules, how you play Monopoly, for example, those generally speaking, standing alone, are not subject to patents, are not patent eligible, as we would say. So it's a big dispute, and it has continued to be a dispute even to this day. I mean, I do a lot of AI work as well, and it's an area where no one really has a clear answer, and it's constantly disputed. So it's one where when these patents get popular, it's not unreasonable for people to look at them and go, well, wait a minute, why were these granted in the first place? Why are we giving, patents on game stuff? And the answer is, well, that's kind of the point up to a certain point. We want to give patents to game mechanics of a sort. It's just the question of where that line is drawn.
So when we talk about these sort of eligible game mechanics that you can patent, so these have to be inventive in some way. They have to be non-obvious. They because the law sort of understands, right, that artists pick and choose from different places. They combine different things. Everyone's sort of inspired by other artists. So they can't just be like an obvious, I took this from here and I took that from there and put them together. That's not a patentable thing, right?
Bingo. And that's one of the biggest areas that people actually have an issue with a lot of the game patents they see is that there's, speaking with U.S. law kind of exclusively for the time being, there's a world of dispute over what we call subject matter eligibility, whether or not something should be a patent in the first place. On the other hand, there's a dispute over whether something is what we call novel and non-obvious. Now, in the U.S. context, novel means the first person to do it, absolutely. And non-obvious is kind of what it seems to suggest, which is it has to be something that it was not an obvious combination of stuff that was already out there in the world. That becomes very difficult in the world of software, in the world of video games, where there's just a lot out there and there's a lot of innovation. There's a speedy sort of development. And as we probably will get into, it's sort of hard to prove what has been out there because it's not as well documented as your traditional science or engineering type stuff because, you're not publishing papers on the latest, version of a video game. So nonetheless, so there's really two prongs here. One of them being, should it ever have been granted a patent in a subject matter sense, which in most cases, courts are generally falling the category of yes in most cases for video games. On the entire other side of this, and where a lot of people also have an issue, is whether or not something is truly new. So that's where a lot of the rubber has hit the road with a lot of these.
How often is it for like a true game mechanic in the abstract sense to be granted a patent as opposed to something that solves a technical problem? Because I think it's easier to understand if an invention sort of solves a technical problem, like an MMO needs to come up with a way to handle a whole bunch of messages or, a new type of video compression. Like those, I guess, are, solving a technical problem. It's easier to imagine a patent. But how often do we see a patent when it's just purely game systems and mechanics?
It sort of depends on what examiner you get and how sort of the current state of the law, but I'll say it's pretty broadly defined. I mean, one of the more interesting examples that comes to mind is that the video game Eternal Darkness Sanity's Requiem for the GameCube, there is a patent on the sanity system in there, which you might initially go, well, that's sort of gameplay, but sort of not, because there's elements of it where, for example, it's pretending to modify your TV volume, for example. There's stuff like that where the line is a lot more blurry than you would imagine, and it sometimes depends on, again, the state of the law at the time, as well as how the USPTO examiner views your invention in view of sort of the technical milieu of what you're doing. So, for example, if I were to go try to patent the general concept of putting poker on a computer, they would probably tell me no, because in the parlance of most patent offices, they would say that you're using a generic computing device to implement an abstract idea. But then if I begin to make improvements on, say, how the game is displayed, how the game is interacted with, perhaps a networking dimension to it, then it gets more interesting. So that line gets pretty blurry pretty quickly. But suffice to say, there's not an absolute requirement that you have to, for example, improve network technology, improve storage technology. You don't have to go, redefine how we store data on a computer to make this happen. Unfortunately, in many cases, it depends very much on the context.
So it doesn't really make intuitive sense, but Nintendo and the Pokemon Company, they've pursued patents relevant to Palworld after Palworld was already released. And in Japan, they've actually modified their own patent while litigation on the patent was ongoing. So how is any of that possible? How can they pursue a patent, file it, get it approved after Palworld was released, and then claim, hey, you're infringing on this patent?
So it can look very confusing from the outside because a lot of the information is sort of buried within literal stacks of paperwork, but I'll try to boil it down very simply. So it's correct to say that there are issuances coming out long after Palworld has been a game. What that I would say, however, is that oftentimes that's conditioned on the original filing date of an application being long before, say, whatever you have an issue with it, being Palworld or otherwise. So, for example, let's give a generic example. Let's say I file a patent in 2010, and that application might be pending for a number of years. Some of the ones I've worked on personally have been pending for 15 plus years before something gets allowed. But let's say I get it allowed in 2011, right? It takes 1 year, which is very unrealistic realistically, but let's say I get it allowed in 2011. I have the opportunity then, and Nintendo's been doing this, to file what's called a continuation application. So I'm saying, look, in addition to what you just granted, so the original application turning into an original patent grant, I can spin that off into a continuation application so long as I filed that continuation application before the formal grant of the original patent. So what that means is I could have a continuation application, pending from 2011 to 2012, and then another one from 2012 to 2013, and so on and so forth. This is very normal because oftentimes what happens is within patent applications, you're describing multiple really good inventions, but the USPTO wants you to focus on really, one specific genre of them within your claims, right? They don't want you going after everything. In fact, they can reject your claims if you try to go, whole hog on everything at once. So your continuation applications continue to be kicked down the road for quite some time. So it's not unusual to see something that was filed, say, 2010, in more realistic terms, timing-wise. It might be 2015 by the time I get my first grant. I might have a continuation application until 2020. I might have a second one until 2025. And that lit can continue on until the essential length of the patent itself, which is 20 years. So within that 20-year period, so long as I have good patent attorneys, the money to do so, and I am dutifully filing my continuation applications, I can keep going. And that's where you're seeing a lot of folks get a little bit confused as they go, well, wait a minute, these games have already been out there and this is getting changed, revised, whatever. What's happening is that original filing date is purportedly before the games themselves. So that's where that's coming from. And there's a lot of confusion about that on the internet because these things can be sort of not easy to understand or sort of read through because, again, this is a specialty form of law that is not made to be easy. It's, based on over 100 years of people going back and forth on this. But that's really what's happening is that, these veritable stacks of paperwork continue to be kited along for up to 20 years.
So these later patents, they're sort of grandfathered in because they're connected to a prior patent, but it's that earlier filing date that applies to the later patent. And so I guess it makes administrative sense that, the patent office would say, let's sort of sort out what we know is okay, and we'll grant the parts that we know are okay, and then we'll worry about the other stuff later. But companies can also use this as a strategy. Is that right? They can sort of like daisy chain these to remain agile and respond to the market?
Absolutely. I mean, within certain limits. So that original filing has to contain everything you wanted to enjoy the benefit of that filing. So for returning to my example, I had to, in 2010, file everything I wanted to go for to claim the benefit of that priority date. So in other words, I can't just add completely new content to that. I mean, there's a mechanism to do that, but then I lose my 2010 filing date, basically. So in other words, as long as I described it within 2010, or it could be fairly read into there, yes, I can continue to daisy chain them. And you're absolutely correct. It's a common strategy to maintain continuation applications, and in fact, keep them open and kind of pending until you know how you want to curve it. Now, there's a legitimate reason to do this, right? So I'll give you an example. I work with a lot of small companies who do this, and the reason why is because when they're fighting the big gorilla mammoth companies, those companies are not dumb. They know how to sort of gently refine their software, hardware platforms to get around certain things, and they're very aware of when there's a potential legal threat. So they'll play games about it. They'll make small little tweaks here and there based upon what you've gotten granted as a patent. So you do want that opportunity to say, hey, look, no, you're just playing games here. Let me use this continuation application to squarely get in there and sort of attack what you're doing. In some cases, what we do with those continuation applications, we will go what we say is broader than what was originally filed. So if this is a very simple example. Let's say my very first application says, I'm going to claim the idea of a moving character on the PlayStation 5. Then the next application, the continuation application, might say, I'm going to claim the concept of a moving character. Now, I'm using very simple examples here, but that way I've broadened it out to be a broader class of hardware, or I can do a broader class of, mechanics, right? So I could say, well, it doesn't have to be moving with the joystick. It can be moving with any sort of input that a user provides or something like that. So that's usually where that goes along. And it is a valuable mechanism to make sure that if you genuinely invented something new and novel, you're not necessarily getting screwed on the minute details. You're allowed to curve it in the direction that more broadly describes what you invented. But again, the most important thing to remember, and this is a very common source of confusion, is that it must genuinely have been filed originally in that first filing. If not, then that continuation application, might accidentally be granted, but there is a major issue with it. And there are mechanisms by which you can attack the patent because that concept was not originally disclosed.
Reading those claims seems like, I don't know, like the Dark Souls of patent law or something, because, I was reading about the situation, which was fascinating. And, this underground battle in the industry, which is very fascinating to me. But then, I dove into reading the actual claims and I was like, oh my goodness, I don't know how you do it, Kirk.
No, and some of that, I'll be honest with you, some of it's standard form. Like a lot of it is stuff that we can read through. So, for example, a lot of folks I remember seeing on some website were getting very confused about the fact that one of these Nintendo patents says one or more non-transitory computer-readable media storing instructions that, when executed by one or more processors or computing device, yada, yada, yada. The reason I can read that off the top of my head without looking at the patent is because that's standard form language. That's saying it's some storage device that contains the code. That's all that's saying. One or more computing devices comprising one or more processors and memory storing instructions that, when executed by the one or more processors, cause yada, yada, yada. More form language. So we're used to stuff like that. We do that on purpose. And there's a lot of old school reasons we do it. But thankfully, that means that when you really get down to it, the practical nut of those claims is much more specific than you'd imagine, even though they're long as hell.
It sort of has to give that preamble to say, like, this is a game first, right?
Basically, yeah. And we have spent, years and years and years as a profession for finding these. So the most common ones, just to let you know, one of them is called a method patent. So it's a method comprising, it's saying, a process of doing. So the old school way to do that back in the 20s would be like the way to make rubber or something like that. Nowadays, with these type of patents, you'll oftentimes see them described as either a computing device with processors and memory that execute something. So that would be like console, computer or something like that as executing the instructions. And then more commonly, you'll often see, especially in these Nintendo patents, what we call computer readable media claims, which are saying the instructions themselves, whether or not executed. So, for example, the actual code itself as distributed, say, whether or not in an executable form.
It's sort of like the patent law version of knowing 50 digits of pi.
Basically, yeah. It's once you get used to it, it's fine. I mean, it takes years and years. It's the reason why a lot of us, there's a separate patent bar for us. You have to take a second bar exam. That's why, legally speaking, all of us have to have an engineering degree of some kind or a science degree of some kind. This is a weird world of nuance, and it's not very popular. The only cool patent lawyer to which I'm aware was Calvin's dad from Calvin and Hobbes.
Oh, right. Cool. Yeah.
Yeah.
Nintendo's been, and the Pokemon Company have been sort of mid-litigation in Japan for a while, and they've been kind of posturing in the US towards litigation. Can you talk about the patents that Nintendo had in Japan and the way they're sort of like altering that and the patents that they had in the US in preparation for litigation, and also at the same time, we've seen Palworld change and sort of provide a moving target almost for this litigation by changing the flying system and the flying mount system, so that if those patents were ever to come into effect, Palworld is making sure that they're not infringing anyway.
Sure, I can speak at least to the Nintendo stuff. I can't speak too much to the Palworld stuff. So, with respect to Nintendo concepts, really, what they're doing is not unusual for what we would consider to be a good old-fashioned international filing strategy. So you're pursuing patents where you can. So in this case, it would be Japan and America, among others. And you are, like I mentioned before, you're curving them using continuation applications or divisional applications or whatever sort of the local law allows to sort of better target what you want to go after. That's normal, candidly. What we might have an issue with, of course, is whether or not that should be allowed in the first place, but that's a whole different story. In many cases, it's not unusual when this is going on for competitors to intentionally look at that and go, okay, well, I need to anticipatorily get around this. And it's not because anyone's admitting that they're infringing. In fact, oftentimes they're still not. It's just that, from a comfort perspective, you want to make sure that you have such distance that the likelihood of you getting sued is lower, especially if you know that you've got a bully in the market who has questionably allowed patents. You know they should never have been allowed, but you realize in the back of your head, do we really want to go into multi-million-dollar litigation to prove that? So I've represented a number of companies. For example, I've represented some of the cybersecurity space where they sure as hell have a very good argument against the patent. But does that mean that they have, $5 million to prove it? Does that mean that they want to spend that time? Or can they workshop with their inventors in one afternoon in a way to very clearly give themselves a definition around it and then just kind of live with the blowback? And in some cases, there's a public perception battle to be won here, is that, sure, your customers might complain, for example, if you remove a cool feature or if you are to modify something. So in the cybersecurity space, removing a feature, for example. But your customers aren't stupid. They know what's going on here. They know that you're being bullied. In that case, the feature is gone, not because we wanted to remove it from our firewalls, but because, someone came to us and is threatening to sue us for millions of dollars over something they should never have had in the first place. We're just protecting ourselves. We want to continue to be your good, firewall company, for example. That's unfortunately common. And thankfully, those battles are just as equally fought out in the public, the sphere of public opinion as they are anywhere else. But it sucks. I'm not going to lie to you. Like, it's unfortunate that because of bad patents, folks who are threatened by those bad patents have to go overboard to make sure that they're protected. It is a common story, and candidly, it's a fun discussion between a lot of patent lawyers. Again, I mentioned I was at a conference recently, and it's now pretty common for plaintiffs' lawyers in the patent world to want to have a broad set of, like, a big chunk of different patents that cover different things, because it becomes even harder to avoid them, right? You're creating a bigger umbrella of things you can't do. Even if those patents are bad, it is much scarier and harder to get around, and they know that. So it becomes a strategy to see how difficult you can be to deal with. So even if I, as the proverbial firewall company, were to modify and remove stuff from my firewalls, it becomes harder if I'm dealing with 50 different patents that all deal with different functions. How can I decide what's truly there and not? Maybe that pushes me to just throw some cash over the fence and be done with it. So it's an unfortunate battle that's not uncommon, but it can be very frustrating because, especially if you're dealing with a big company with very deep pockets, the scope of difficulty becomes significantly higher.
That sounds horrible to me. It sounds like an arms race that I sort of don't want to be in the games industry because I feel like it could be dangerous for the art form. How common, I mean, obviously you've seen that in multiple industries. How common is that sort of activity within the game space?
It's relatively new, to be honest with you. I mean, games have been subject to patents for a very long time. In fact, our firm runs an entire blog logging different patents. And many of them, between us, if we're being real, were probably gotten not to use against other people, but for one or two reasons. One of them was to reward an inventor, right? You want to give them a reward for being clever and coming up with something that no one else did. IBM has done that for a long time. I believe they were the ones who started with giving like decorative cubes every time you got a patent. A lot of companies give you money in addition to that. So there's reason to reward people. And the other reason is defensive, right? So many companies get patents not necessarily planning to sue someone with them, but because they know that if they were to be sued, they would have some of their own to defend themselves against. And that's actually one of the more common uses of getting patents nowadays, is to have your own war chest of things that you're doing so that, A, people can't knock you off directly, and then B, you have some sort of something that you can go to if someone threatens you. So this, however, is a relatively new dynamic. To my knowledge, there's not been a massive blowback on this. There have been plenty of disputes on the patent side on smaller stuff, right? I mean, one of the more infamous patents that many people still talk about to this day is Nintendo, for example, did have a patent on the old school D-pad. And, that's an old school hardware invention. It was a really good D-pad. So, of course, people wanted to use it. But they had that for a very long time. And they would prevent other folks from using it ostensibly. And, it's hard to prove this because a lot of this happens outside of the public eye. If some, Mad Cat style company were to go try to make a version of the D-pad, they probably received a cease and desist letter from Nintendo. So, stuff like that's been going on a little bit here and there, but this nature of broad scope, crush a competitor style game fight is relatively new. There are small examples here and there, but really this is one of the more notable ones.
Yeah, I came across some quotes. Florian Muller said, "This is by far the most aggressive patent enforcement any game maker has ever attempted against a rival," referring to Nintendo. I think I came across a quote from Don McGowan, former chief legal officer at the Pokemon Company, saying, "I wish Nintendo good luck when the first developer ignores this patent," sort of suggesting skepticism.
Don's like that. Don's a very good guy.
Yeah. So, from my understanding, they had a couple of sort of semi-recent patents that had to do with the switching of mounts in the game and the ability to throw something and capture a character. And then the more recent one had to do with summoning a character that could potentially fight for you, either in an automatic sense or in a controlled sense. And really, these are very basic game rules. I mean, in terms of, the sort of solving a technical problem that we talked about before, I know a lot of developers. I, have made some games myself. I know you could walk up to anyone who knows how to use a game engine and said, could you make these features? And they would say instantly, yes. Like that's not hard at all. We do that stuff all the time. And so alarm bells should be sort of going off in gamers' heads, because how many games have a summoning system? Like, how many RPGs have a necromancer or a warlock or a hunter with pets? And now you've got, or how many times have you summoned a vehicle in a game? And, and sort of now Nintendo and the Pokemon company are saying, actually, we own that and we're going to assert that for the next 20 years.
That's the kind of confusing thing here, because on one hand, we could talk all day about whether or not this is subject matter eligible. I think in general, the answer is probably somewhere close to, maybe, right? Like, it's hard to dispute. It's hard to say, because this is an area that's been nuanced. But from a novelty and non-obvious standpoint, these patents are dubious at best, and at least in my opinion, completely unallowable. Like, you're right. There have been decades at this point of games that have used mounts, summons, necromancers, you name it. So the general concept of summoning, even when we go through the specific, narrowly defined scope or allegedly narrowly defined scope that is the claims, that isn't all that clever. And granted, there are plenty of patents out there where, in retrospect, as we saw with the benefit of hindsight, you go, oh, well, duh, right? That sometimes happens. But with these, you look at them and go, that's not totally new at all. We could have done that in 2 seconds. Moreover, it's probably already been done. Now, what's interesting about that is that we see that as gamers because a lot of us have personal experience with these games. Unfortunately, this is in some ways a unfortunate side effect of what's been going on at the patent offices. Like I said earlier, there is a lack of good, employee availability at the USPTO. There are too few of them. They're too busy, and their systems are fantastic, but they're really not made for searching up video game art, right? Because you got to think about it. Like many other examiners and what we call other art units, like mechanical stuff, you go look for a gear, you can go find a gear. You go look for an engine, you can find an engine. For video games, oftentimes we're describing things in a more functional basis in ways that can be described in multiple ways. And video game concepts, mounts, etc., don't always end up in scientific publications, written documents, etc. Right? So, for example, the particular nuances of how mounts worked in some particularized version of World of Warcraft, there might be some wiki out there, but it's going to be harder to find than, say, some old school document published by a university. So what that means is you've got examiners who don't have a lot of time. Their systems are really not made for this sort of searching, and then they just don't have the ability to find the stuff that they need, because unless they have personal experience, they're not going to see what they need to see. And that might underpin why there wasn't much of a pushback on these, even though we in the world of, game development and game engine, things like that, go, well, duh. Because proving that can be a bit harder than you would imagine, especially from a legal perspective. Now, granted, there's plenty of stuff out there that shows that none of this was, new at all. But if you're an examiner who has a literal clock ticking on you, proving that would have been very difficult. So that's why we begin to see, I think, these things get sailed through, is because there's an argument to be made that the USPTO examiner or even the Japanese examiner goes, well, I don't have the time. I can't prove, this may have been doable in WoW, or hell, there were mounts or ships in one of the old Ultima games. Maybe that could count, but I don't have the time to go look that up because I'm on, hour 3 of 5 and I have to draft up this long document to prove what I've said. So crap, I'm going to leave this to the lawyers on the back end of this to handle through lawsuit or an IPR, assuming that that's available to them. Unfortunately, that means that Nintendo does get that patent, and we're now having to deal with the consequences of that. But that might have been the logic is, sure, most of us who know better know this should have never been allowed, but that doesn't necessarily mean that an examiner would have found as much at the time.
There have been some reports about the lack of investigation by the examiner. Apparently no Google searches being done. I mean, this is the type of thing that you can chat to any gamer and they'll tell you, yeah, I was summoning my demons in World of Warcraft as a warlock back in 2006. And we also had flying mounts, in that game, not for nothing. So it's like, I guess the only way you can kind of explain it is someone who was really pressed for time and resources.
Kind of, yeah. And, good patent attorneys who are doing their job, like when I'm prosecuting a patent like this, right? I send them the best things that I'm aware of. And the reason why is because I want to make sure that my patent's good to go. I want it on record that this examiner took a look at whatever would be a problem and went, even despite that, this should be allowed, and here's why. This didn't happen. So turning, for example, to the sort of boarding instruction patent, the mount character, the patent that Nintendo has, the very first filing there, which is the 255 patent, that was basically allowed with barely any pushback. Most claims were allowed, so that usually you file 20 claims. The vast majority were allowed. The few that were not allowed were rejected on a YouTube video about mods to a game called Ravenfield, I believe it is. That was it. The examiner found some YouTube video, used a transcript to say, it sounds kind of similar. And that was it. One singular reference. And of course, Nintendo's attorneys goes, oh, sure, we'll cancel those. We'll take the allowable ones. We'll go home.
Wow.
And then file a continuation. But that's a scarily low amount of fight for something that's so high level. Now, granted, part of this, again, put yourself in the shoes of these guys. I'm not trying to criticize the USPTO at all. I get it. You're sitting there. You have a literal clock on your time. You get something that perhaps you're not familiar with. These claims are long and they are detailed. They're not as clever as they look, but they're pretty lengthy. And remember, you have to show that every single word in there is in some document somewhere, right? You have to show that it's not new or non-obvious, you have to show it is new and not obvious by documents. And proving that's going to be a long time. There's not that much out there. And again, what might be out there requires some pre-knowledge of the games industry as a whole, which you might not have. So you might find this YouTube video, which gets you close enough on some of the claims, but do you really have the time to go and, investigate whether, the ship you can get in Ultima is close enough? Who knows, right? Like, at that point, you just kind of allow it and you move on. And that's unfortunate, but that's somewhat close to reality.
Yeah, definitely. It's a good point. On one hand, I'm baffled by this, but on the other hand, this is very much my subject area. So, of course, I can remember all the times I summoned creatures and stuff. In what ways do you think the law has done a good job of keeping patent law where it should be? And in what ways has it done a bad job?
So it's tough to say that because in many cases, when you speak with attorneys on this topic, they'll call it a pendulum, right? We've been swinging back and forth on the topic for a long time. There have been major cases in, say, the early 2010s, even in the 2000s, where the courts were really trying to explore the limits of what we call patent eligibility. And in some cases, they've said things like, look, we want to have sort of a big tent on this, right? At least in the United States, the definition of subject matter eligibility is quite broad. And in fact, in recent years, and actually within the last month, there have been multiple court decisions as well as USPTO guidances that have effectively said, look, y'all need to grant more because they have increasingly swung the pendulum too far in favor against allowing patents. And it has been discovered that, look, if we, say, as the Americans do that, and if other countries don't do that, then we are unfairly penalizing companies that might otherwise get patents, right? So if it's going to be allowed in Korea, there's an argument to be made that we should be allowing something roughly equivalent in America because we want to extend that protection over here as well. So in general, it really has been a pendulum. There have been instances in which many folks have argued that it has been too onerous, such as in the last couple of years where the USPTO and other patent offices have been very strongly against allowing anything that they surmise could be directed to a abstract idea. And then previous to that, really, I would say probably 90s, 2000s, there's a pretty good argument that it was too lenient. So you'd see a lot of patents that came out that were pretty closely directed to what we would call business methods, which is sort of a per se not allowable sort of thing. To that end, there have been instances in which the patent offices across the globe have tried to reel back that over-permissiveness. So in the United States, for example, we had a variety of tools, some of them still available. One of them was called a business method review, which that basically was an attempt to allow people to bring patents directed to business methods back to the USPTO and say they should never have been granted. And today, although somewhat weakened in recent years, there is what's called an IPR, an inter partes review, where again, someone who's aggrieved by a patent can go back to the USPTO and they can say, hey, look, this should have not been granted. And, I'm threatened by it. They might sue me on it, for example. So I want you to destroy it. And it kind of works. Unfortunately, that's been gutted in recent years using a process called discretionary denial. But the principle still remains, is that this has constantly been a oscillating sort of standard that no one can really define the particular location where it exists in a given time.
I'm so glad you brought up the IPR system because I came across that in my research, and seemed like it was supposed to be an easier way to challenge patents, but it looked like this a lot of challenges were being rejected due to the term that came up was discretionary reasons.
Yeah.
What does that mean? And is there like a certain kinds of patent challenges that are being rejected and certain kinds that are not?
So the unfortunate answer is nobody knows, and it's frustrating the entire patent bar because this is a relatively new thing, and it depends on how you look at it, but I'll give you kind of the breakdown. So as of recent, it's been pretty well known, I would say, that within the United States at least, the USPTO is overburdened. In fact, you might argue that's why, for example, Nintendo is getting a lot of patents they're getting, is because everyone at the USPTO is too busy. They're not getting enough time to do what they need to do. There's not enough of them. You need super specialists in certain areas. That's way harder to do than you would imagine. So as a consequence of which, there has been an effort by what's called the PTAB, the Patent Trial and Appeal Board, to sort of lessen the load they've been dealing with. Because with IPRs, you're absolutely correct. You can go to the board and you can say, look, this patent should never have been granted. And you can save yourself millions of dollars in litigation costs if you're able to prove it, because you're able to get rid of the patent that someone might have sued you on, even if they've already sued you on it or if you anticipate that happening. So it's a pretty powerful tool, and a lot of folks, myself included, were using it, even though standing alone, it was quite pricey. It was $250,000 or more to do it, but that's still way cheaper than getting sued, right? So you'd still do it. And this discretionary denial process is really a loose set of guidelines that the PTAB has put forward, trying to say, hey, look, when we see things we don't like, and I'm paraphrasing here, we're just not going to do it. We're going to tell you, no, we're not going to grant that IPR. And it's very concerning because these discretionary denial factors, such as what they call settled expectations, no one really knows what that truly means. There's plenty of folks who have done very good research and tried to kind of define that in terms of patent duration, prior negotiations of the parties, you name it. But we really don't know. And it's a problem because that means that if you are someone who's threatened by a patent, say, for example, some game company has a massive patent, they threaten to sue you with it. IPRs are available, but there's always that little risk that for procedural reasons having nothing to do with the patent itself or allegedly, having something to do with the patent, you might not get that IPR. What that means from a legal standpoint is that your methods of defense for yourself really fall down into one of two there's a few others, but there's two categories really it falls into. One of them is you just wait until you get sued, which sucks because you're spending, again, millions of dollars. The other one is you proactively sue in what's called a declaratory judgment action, which you go to the court and you say, hey, I think, I'm in risk of this thing. Let me defend myself. Again, that's extremely expensive. So one way to look at this entire Malo is to say the process of defending yourself against a bad patent, if you think it's a bad patent, has gotten significantly more expensive and onerous. So the threat of them is much higher than it used to be.
Wow.
Yeah.
I had no idea it was so mysterious.
Yeah.
And
it's always fun at the conferences, like I was just at one in Palo Alto. You can get patent attorneys rambling with anger about this within about 10 seconds because everyone's pissed. Like, granted, the what we call the plaintiff's bar, the guys who are suing often, they're pretty happy about it because the value of their portfolio is just raised. They can threaten much more effectively than they used to be able to. But it's still concerning because none of us know what to do. And when advising clients, we have to be real with them. We're like, look, we can still file an IPR for you, but the denial rate is, I think, north of 60% now, just on procedural grounds. We're not even talking substantive grounds. So it's a little dicey.
Interesting. Thriving on the chaos.
Oh God, yeah.
When Palworld came out, everyone kind of it was a sensation. It was a phenomenon. It, had massive player counts in the first month. Made a lot of money as well, and a lot of people. Probably even before it came out, when they were showing it earlier on, people noticed the sort of visual similarities between the characters and Pokemon characters. And, there was almost a sentiment of like, Nintendo's might. Nintendo's been pretty litigious in the past, and people were kind of wondering, like, hey, when's Nintendo going to sue? And people were kind of making that, casual judgment just based on the visuals. And so I guess I'm kind of curious as to why Nintendo and the Pokemon Company are pursuing this path of patent litigation as opposed to going after the art style. Because, I'm sure there must be a legal reason for it, but even beyond the legal reason, when we talk about the court of public opinion, it seems to me like the visual stuff is what people will understand. Like, that would be more like, yeah, we can understand why Nintendo would kind of go after the art style. But the patent space where it's like, abstract concepts and game mechanics, like, in a legal sense, those are supposed to be a bit more protected, but also in the court of public opinion space, it's like gamers don't like that. It's going to be an unpopular move if they're sort of trampling on the art form like that.
So let me kind of break down copyright because it's a more interesting distinction that has some very interesting implications for gaming. So copywriting in general, the copyright law, does what it says on the tin. It only protects against copying. So what happens is, unless you can prove direct copying or what we would consider to be from what are called the character cases, reuse of substantially similar characters, story, etc., you can't do much with copyright. And the reason why, simply put, is that we want people to stand on the shoulders of giants creatively and to iterate in that way. In fact, many games, you would argue, are iterations of each other that simply improved on one or more aspects, as long as they're not using the same characters or the same story, and even then there's a dispute because, tropes are tropes, or the same code, for example, because code is copyrightable, then you can kind of do what you want. And that's intentional. That's part of the system. We want people to create better versions of art styles, stories, etc. In fact, generally speaking, art styles themselves are not copyrightable, right? So, a certain style of game, cell shading, certain hyper-realism in games, you can't protect that either. That's just not amenable to copyright. So an example I'd provide is, let's say I created a new video game. If I were to go steal an asset, like a sound effect or 3D model, sure, I could be sued for copyright because I've literally copied it. If I created a game with Pikachu in it, well, and that's a copyrightable character, I could get sued for that. However, if we're talking in the more general sense of, can I create a game that, can I create a Metroidvania? Well, kind of, yeah, that's a genre. That's kind of how games like Bloodstained exist, is because they realize that you can create the same Castlevania-esque art style, Malo, gameplay style, whatever. And as long as you're not copying stuff, as long as you don't have the Belmont family and you don't have the code in there, you're pretty good to go. And that's a design for the system. We want people to iterate on it. It's a very good thing. And one way to phrase this would be, you don't want the other way around, because think about what would happen if, for example, we allowed major game companies to monopolize certain, say, art style, game styles, genres, etc. Then they would just go prevent any indies from existing whatsoever, right? Most indie games will be crushed within seconds because, they are in some cases inspired by what they've played before. The entire genre of RPG Maker horror games came from somewhere, right? So, the people who ever made that, was it House for the NES, could go after them. So it's a bit of a problem. And we do this on purpose. We want people to be doing it. So the good news is, if you're an indie developer in that area, art styles writ large, not really protectable.
Interesting. That very much relates to my next question as well, because in Japan, the Pocketpair Defense has listed a lot of prior art, and prior art is things that you can point to in the medium that have done similar things. They don't have to be done in the exact same way, but you can point to them and say, that's been done before and that's been done before. And so among the prior art that they listed in their defense were several games, but also several mods. And I wanted to open the discussion to how this is going to affect the mod space, because Nintendo sort of came back with the response and said that mods should not count as prior art because they can't run without underlying games. And of course, what matters here is whether artists will be inspired by the art or not. But I'm curious as to how it could affect the mod space and where you see that sort of like attack on mods going.
So my take on that is, Nintendo is so wrong it hurts. I don't know why they make that argument. It's weird. And granted, there's some nuance in Japanese law that might dictate where they're coming from. But in general, when we're talking about what we call prior art for the world of patents, it doesn't have to be perfect. In fact, it doesn't actually have to be functional, right? There have been plenty of instances in which prior art has been used that is not even a computer program in the first place. So an example of this that I was not involved in, which is a very fun read, one of the IPRs that came out 5-7 years ago, my knowledge of time is terrible, used one of the Dungeons and Dragons manuals, which is not a video game at all, but it's talking about, character sheets and things like that for the purposes of that IPR. And as a consequence of which, you don't have to go find prior art that's a specific nature. Like, it doesn't have to be marketed. Oftentimes, the minimal requirement is that it's written down somewhere. Like, you have to prove it existed, right? It could have been sold somewhere, and you can prove it that way. But generally speaking, when we're showing prior art, it's some document somewhere, and we're just validating the date in which it came out. So Nintendo's argument that mods are somehow different, to me, is the most asinine thing I've seen, because I know what you're talking about. I don't get where they're coming from. I think it smacks to me as someone who doesn't understand computers at all, honestly. From my perspective, look, mods are valuable. I mean, they are a dangerous area, right? You go to Nexus Mods right now, you're going to see a ton of mods using copyrighted material. And, as an IP lawyer, I just turn my blind eye to that because we all know that's not a good thing. People ripping models from one game and putting them in the other. It's kind of, you shouldn't be doing that. But that's just kind of the nature of the beast. But writ large, like, if you're creating a mod for a game that has certain functionality, that's all that matters. It doesn't matter if it's running on Fallout New Vegas, which means it's probably not running, or any other game, right? Like, it is a function, and that's all that matters from our purposes. So, for sure, there have been instances in which I've been in fights with the patent office, or I've been in litigation, where the references we've used have been things that were never actually made, and that had numerous real-world flaws. But that doesn't prevent them from being prior art, at least in the United States. Now, there may be some nuance there in Japanese law that I'm not aware of. I've done quite a bit of Japanese patent law myself, but, there may be some nuance there. But in general, I think that argument's a loser. It's one that is fixated too highly on form over function, which is just a bad idea. Because where do we end that dispute, right? There are plenty of Unreal Engine 5 games. Are those mods too, just because they're running on a singular engine? Like, it gets into this weird dispute that no one knows what the hell's going on anymore. So, from my perspective, it's just a loser argument from Nintendo. I think that they're trying to throw a Hail Mary because there's so much out there. I mean, I've had the luck of having a lot of fantastic folks email me more and more examples of what they've found, in addition to what we found ourselves on things. And the list is becoming so incredibly long, it's actually kind of funny.
I could imagine, yeah.
So it's kind of great because, you realize, oh my God, now I have this opposite problem of now I got to pick my favorites to raise because you don't want to overwhelm a court. But it just goes to show that, they're trying to throw some Hail Marys because I think deep down inside they know these patents are junk. They don't want them to be invalidated. They don't want a bad mark on their record. But, mods, that gets in this weird definitional case. I would never make that argument in a million years.
So don't worry to the modders that are making the Pokemon mods in Dark Souls and Minecraft, and
just don't be copying, Pikachu or anything like that. That's obviously my problem. I mean, honestly, those mods have been a very valuable source of a lot of stuff. I've seen them used in other contexts as well. In fact, that thing I mentioned before, the first reference used against the 255 patent, one of I believe the mounting one, was a mod for that game. It was an actual YouTube video of a mod for a game that no longer exists. So it's fair game, very much fair game.
Well, Kirk, I know we've gone past your time. Thank you so much.
Not a bit. I'm always happy to see people on this. You can always reach out to me. I'm all over the internet, so you can always usually find my information. But, of course, I can't speak to Palworld stuff for obvious reasons. But I'm always happy to talk about these things because it's fun. I mean, I just finished up a fellowship in the topic, so I love to rant about my video games,
Awesome. Yeah. I'm so grateful. You gave me some clarity on an issue that's pretty complex. And thank you so much for that, man.
Sure, no problem. Really appreciate it.